Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a new case law on Section 9 of the Limitation Act. All of you know, Section 9 of the Limitation Act says once the limitation starts running, it will continue to run till the end period. It will not stop for any disability or other things. That means, suppose if you write a promissory note on 30th October 2023, by 30th October 2006, the limitation period will be over. Till such time, this will be running. So likewise, the starting period is more important. In the case of Sabbir, of course, both of them are died. Sabbir, dead, represented by LRS versus Anjuman. He is also deceased, represented by LRS in civil appeal number 6075 by 2023. Right? The matter came to the notice of the so-called Honorable Supreme Court of India. Supreme Court of India, I think two judges bench has Vikramnath and Asanuddin Amanullah. They held that the limitation runs from the date on which it is fixed. And you cannot say that he has refused to take and other things. If you know the case law, then it will be better for you to appreciate. Of course, this case also dates back to 1975. Right. On 31/7/1975, please remember, the appellant, that is Sabbir, he is dead. Sabbir has executed, I can't say executed, but he has executed an agreement to sell. We can say it is 8 years agreement to sell by taking 1,000 rupees as advance. The deal was fixed at 6,000 regarding a site. So the agreement to sell was written that the person has received the so-called advance of 1,000. Then he has to apply for permission from the collector within 7 days and get the permission. If not, the agreement is not valid. Of course, the land may be like our DK land or other things. The permission of the collector is necessary to dispose the land. But they did not do so. The appellant did not apply for the permission. These people waited for 5 years. During the year, on 1/1/1981, please remember the dates, 1975 and 1981, that means almost after 6 years. They have sent a notice, they filed or they have instituted the civil suit as an original suit. Right. So, the OS was filed in the year 1981. You know, according to Article 54 of the Limitation Act, the suit for specific performance may be on the agreement, whatever it is for 3 years. Here, the important point is how the 3 years should be calculated. Supreme Court clearly stated the matter moved right between the trial court, the High Court, first appeal, second appeal. Ultimately, the matter came to the Supreme Court. Right. The trial court clearly held that, please remember, the limitation starts from the 9th day or 8th day, we can say. So actually they have promised 1 week. Previously they used to take it as 8 days. So if within 8 days they did not apply for permission, then right from 9th day till the 3 years, the limitation periods will be there. they have to institute the civil suit between that means maybe in the year 1978, but not 1981. But how these people are managed, they manage the lower court. This is also important. They stated that the appellant Sabbir kept them with false promises that he is going to apply, he has to apply, he has some time, he has to meet somebody to apply, all the things they have been telling, therefore the delay. Now, the Honorable Court, they have looked to the notice issued by the respondents to the appellant. In the notice, no averment was made that the time period they have been dragging on, and secondly, the so-called 8 days period is over and the period is getting completed like that. They have not made any mention regarding a particular aspect. That means they know that these people did not apply for the permission. And secondly, the respondents, they did not make any mention that they are ready and willing to pay the variance consideration. You know how they do it. Normally, in our day-to-day practice, we will be saying, the party is ready. The party has deposited the money in the bank, or the money is here. We are ready to perform our part of contract. That is, we are ready to pay the money. Please come and register. That they have not mentioned. That means they have slept over the matter for the 5 years and later only they have filed this, instituted this civil suit. So basically it has to be dismissed in the threshold itself basing on the point of limitation. Right? So question. Now the appeal was allowed and ultimately the appellants were successful because the respondents could not institute the suit within the period of limitation. That is the effect of limitation. Therefore, please remember, in the interest of Republic, or I will tell you, that is interest Republicae ut sut finis litiam. This is the concept. Please read the case law and enrich your legal knowledge. Thank you very much.